All right, so the saga of Zee Entertainment's board and its tussle with its largest shareholder is nowhere close to ending. It seemed like there was a happy ending for all after Zee signed a non-binding agreement with Sony to take over the company and merge into Sony, but it's not going to be as easy as that because Invesco, which holds 18% of Zee, has insisted that its call for an extraordinary general meeting with the agenda for the removal of Punit Goenka as MD and CEO be adhered to. They've in fact moved the NCLT in demand of this, and the NCLT has asked Zee board to listen to this and react and respond positively. Now, technically, the Zee board has till the 3rd of October because they have to make a decision and give a date for the extraordinary general meeting within 21 days of when it's called, and those 21 days now will lapse. So Zee has said that it will follow all of the procedures. But what does this mean for the deal with Sony? What does this mean for Punit Goenka's continuance at the helm? We're talking about that this evening as there has been another twist and turn in this entire story. J.N Gupta joining us on the show, Hetal Dalal speaking with us today as a senior legal counsel, Tushad Cooper. Welcome to all of you and thank you for speaking with us. Let me go across to Hetal first. Hetal, how do you see these developments? Many assumed that Invesco is going to be happy that Sony wants to come on board and infuse more capital, will have 53% stake. It worked well for Invesco as an investor, and in fact the way the stock price also responded seemed to indicate that shareholders were largely happy. Is there another side to the story now?
Look, I think the point of view for Invesco is that they're not sort of opposed to the merger between Zee and Sony. I don't think that's the platform. What they're simply saying is that the governance structures need to be in place. So you ensure that once the governance structures are in place, you have a board which is relatively independent. The decisions which are being made are made in the interest of all stakeholders. Essentially, the argument is that while there is an announcement of saying that there is a merger with Sony and the deal contours are that there is a non-compete fee which is getting paid, Punit Goenka remains on the board as managing director. The question you really have to ask, and this is what Invesco is asking, is could there have been a better deal or a better deal structure in the absence of Punit Goenka? And therefore, if you have an independent board which is more mindful of all stakeholders, are you likely to get a better deal out of the entire structure or a better valuation? Or are there other people who could actually bring in more investment into the business, or you can find a better partner? So these are questions which are open. I don't think the entire perspective of saying that we want to, the removal of Punit Goenka is linked to the fact that they don't like the Sony Zee deal. I think the issue is really separated from that to say that would it have been better if the governance structures were in place? And that's really where Invesco is coming from.
J.N Gupta, we've spoken about this a couple of times now, and at every, I would say, junction of where this entire story has unfolded. Today, we have seen a situation where Invesco is not willing to give up on its basic demand that Punit Goenka must go. They're saying, they're not saying anything about the Sony deal per se. That stage will come, that bridge will be crossed when it has to, but they're adamant about this. How do you read this situation?
See, I cannot speak on behalf of Invesco or G or anything, and neither I can suggest what could have been a better structure or something. I speak on the basis of what is in the public domain. Invesco is within their right to ask for a EGM. There is no doubt about it. If they feel Punit Goenka should go, they have a right to ask. But ultimate decision is with the shareholders of that company, because Invesco is just 18% and there are 82% other shareholders who also have their say. If they feel that what Invesco is saying right, they will vote along with Invesco. If they feel that Invesco is not right, they will vote. But having said that, I would always say that a rational argument has to be put forward. So let Invesco see logically what are the issues, what are the points on which they want Punit Goenka out, on which point they want directors out, and what is the merit of the directors which they are bringing in. That is one part. The second part is the deal with Sony is independent of what Invesco is doing, for the simple reason that deal would also be coming to board for approval after this whole thing is done, and for the shareholder and the same body of the shareholder. Now, assuming a situation that Invesco EGM is done and the board is out, new board comes, and Sony after due diligence says that we want to go ahead. Then this board, the new board, if at all that comes, would have to give a cogent reason to the investor that why we do not want to go ahead. What is the flaw in this deal? The corporate democracy does not mean that my whims and fancy will prevail or your whims and fancy will prevail. Everything has to be told to the shareholder in proper manner. Having said that, I would say the NCLT issue, I really do not understand how NCLT has entertained this thing. It is like this: you are going to a doctor and telling the doctor on 3rd October, I am going to have a stomachache, give me a medicine. Where is the cause of action? If by law there is a 3rd October is there the date, if by 3rd they are not calling for EGM, even then there is no cause of action if you follow the Companies Act and the rules made there. Because that very clearly provides the remedy therein that the shareholder themselves can call EGM, and Rule 7.7 says that in that event the company is duty bound to give address, number and everything of the shareholder, so that the shareholder who has requisitioned the meeting can communicate with this. So the law itself provides it, and they have no locus standi to move to NCLT under 241, because 241 talks about operation and mismanagement. And that operation and mismanagement, first you have to prove this. So I really do not understand. And last point, which I was very much wondering, the NCLT has observed that they should not have declared that they have signed a term sheet with Sony. If they would not have declared, SEBI would be after them. So I really do not know how everything got mixed up.
Tushad Cooper, would you like to come in on this question? Was there sufficient cause to go to the NCLT, even if we assume that Zee board, as Invesco is claiming in the tribunal today, did not want to call the EGM? They still have till the 3rd of October technically to display that they don't want to call the EGM. That time is not up yet.
Now, I agree with Mr. Gupta completely that technically speaking, he is right. Invesco's application before the NCLT was premature. In my view, Invesco determined to move the NCLT because it realized that in all probability, Zee will seek to drag its feet, which Zee had till 3rd in any event to do. The idea was that by moving the NCLT at this stage, it precludes that delay from taking place. So Mr. Gupta is right. Technically, the NCLT ought to have said, your application is premature. If they do not move by 3rd, come back to us. Effectively, the NCLT has more or less done that, because it has merely reiterated what the law states, that you have till the 3rd to make a decision, make your decision by the 3rd, and they have therefore posted the matter for further hearing on the 4th. So technically, they ought not to have passed any orders. They've, according to me, Mr. Gupta is right when he states that the NCLT should have maintained a hands-off attitude, but the NCLT chose to do this. Now, let me look at Zee's position. According to me, on the aspect of comments that, well, it ought not to have gone ahead with the announcing the deal with Sony, why has Zee done that? On the face of it, Zee has not only a right, but as Mr. Gupta pointed out, a duty to have announced that. But I feel that there is something more to it than meets the eye. What Zee has done by announcing this deal with Sony is to try and tell the shareholders that, look, if you try to support Invesco, it is possible that this deal with Sony will get scuttled, because Sony is insisting that we are part of the management structure in the new scenario which will emerge post-amalgamation. post-merger. So therefore, think very carefully before exercising your vote in favor of Invesco's resolution. And I think it is partly to dissuade any investors from supporting Invesco's move, that this preemptive move with Sony has been announced in such a hurry. And I think that is what irked the NCLT. The NCLT felt that this was done with a view to scuttling the steps being taken by Invesco, which is within Invesco's rights to move. Invesco may ultimately succeed in its resolution. Invesco may ultimately fail in its resolution. Having said that, however, one must also bear in mind that at the end of the day, whatever decision the board of directors takes, whether it is the existing board of Zee or a newly constituted board, which may come into being post Invesco's EGM, it will still have to ultimately go to the shareholders for their approval. So if the shareholders are not in favor of approving the Sony deal, and I suspect that the Sony deal will be made more attractive for the shareholders if the Invesco group succeeds in getting in their management, because there are undoubtedly sweeteners also for the promoters of Zee in the deal with Sony. So therefore, there is some legitimacy, in my view, to Invesco's stance in trying to argue that this move by Zee's promoters was, in a sense, to overreach the EGM notice which had been issued by Invesco. Really, I think what has irked the NCLT is that just like justice must not only be done, but seem to be done, what Zee has done is tried to do something which doesn't appear to be fully transparent, fully within their legal rights, but not something which appears to be totally kosher. And I think that is what irked the NCLT into making these observations.
Yeah. No, absolutely. The question also is that was the whole Sony deal at the end of the day an attempt to rescue the promoter family from the wrath of Invesco and from what they were trying to do, which is why Invesco is trying to separate the two. You want to come in on this, Mr. J.N. Gupta. Did Zee show intent of calling an EGM? Because Invesco goes to court and says that all of our communication has been ignored so far. They don't have faith that an EGM would have been called. They don't have faith that, what their rights as a shareholder with 18% stake would be respected and would be upheld.
I really feel the issue is when you give me a letter and I put a 10 rupees round step and give you initial, is this acknowledgement, or when I tell to the world at large that this is the letter I have received, I am publicly acknowledging that. So if the G has put that letter on stock exchange website, they have publicly acknowledged it. That is one. The second thing is this: none of us at this juncture can go into the intent. I do not know what the board of directors are going to decide in a day or two. What is their intent? The third point is this: I don't think any of the court can get into this, that whether the G's intent was to scuttle the move of Invesco. I don't think it is even remotely possible, for the simple reason, even if the G board does not call for the meeting, Invesco can call for the meeting and it can be held within next 25-30 days. So there is no issue, and by that time, Sony deal will not be done. So I don't think one can weave stories into this, because I cannot speak on behalf of G, I cannot speak on behalf of Invesco, but I am speaking that I, as an analyst, will not be able to weave the story that what is in the mind of Invesco, what is in the mind of G. I am saying I read it as it comes. Since everything will go ultimately to the same body of the shareholder, they are the supreme authority to decide. No court can intervene into the judgment, the decision of the shareholder. If the shareholder body decides on a resolution, unless until there is some illegality involved in the resolution is final. So that is what is my issue. I don't say so. I would not buy the thing that it has been done. It may have been done, it may not have been done, but I cannot comment on it.
No, so Fine. I mean, technically, you're absolutely right. But let me take this to Hetal. Hetal, at the end of the day, if you remove all the technicality of it and you see what this story and what these developments are all about, it is also at the heart of it a promoter family wanting to hold on to their position in a company that they have built up. And they don't want the white knight of 2018 who saved them to turn upon them. They want to hold on. Isn't that intent pretty clear at the end of it?
I should think so. Let me just start by sort of addressing the whole piece about, can you read the board's mind? I think Mr. Gupta will also agree that our fundamental role is to encourage companies to look beyond the legalities. Governance starts when compliance ends. And therefore, the right thing for a board to have done would have to be proactive in terms of looking at what the investor wants. And mind you, this is an 18% shareholder. It's not just a retail shareholder holding 10 shares, right? This is an 18% shareholder with, at stake a market cap of, at stake 5,000 crores, who's asking for the removal of the control of the managing director. So therefore, from a board's perspective, they have to be far more proactive in their communication. They should have addressed this issue more quickly and, sort of communicated with the market and the investor in terms of what their goal is. To simply say that silence is therefore acceptable, I think is possibly taking it a bit too far. I think to say that, you have 45 days and sure you have another 45 days in which Invesco can hold the AGM. This is a US-based fund. They're not going to look at trying to reach 2.5 lakh investors and trying to organize this whole EGM, right? It is essentially the responsibility of the board to organize the EGM. Should the board fail, it becomes the investor's responsibility. But the board has to act in the first instance. You can't simply say, I'll wait and let the time slide by, and therefore the investor has the right to hold the EGM. Coming to the whole piece about the whole transaction, and is this really, is this really a survival mechanism for the managing director? If I were to look at it dispassionately from Sony's point of view, right? At the end of the day, with the merger, I'm taking out a competitor. Ad revenues go up, I get more eyeballs. Therefore, from my perspective, it's a great deal, right? Valuations, we haven't even come to it because due diligence hasn't been done. So therefore, it's all debatable in terms of what the valuation will finally end up to be. But Sony is a large multinational company, right? For them to say that I'm going to hold an entire transaction ransom in India where I can actually take over a competitor which is almost equal in size for the continuity of one individual is certainly open to question. If you're going to argue that, the current managing director is the only one who runs who understands the media business as keenly, I would argue Sony has equal and more competence in that particular fashion. So the argument to say that the entire transaction is going to be beholden to the managing director continuing in his seat, I think is certainly possibly too stretch of an argument, is the way I would.
Okay. Mr. Cooper, you wanted to come in. The point we're talking about right now is, will Invesco quietly go away if this deal goes through? They're a large shareholder, they get their due, they go away, or is it going to come down to them asserting that they have a right to push through with something they want? They have a right to push through with this EGM and their demand for the removal of the MD and CEO, and they want to see how it pans out.
Okay, that's exactly, just let me first respond to one point which Hetal made, which was very important. She very rightly observed that there is a clear distinction between compliance, which is what Zee is doing, and corporate governance, which would have dictated an alternative course of action. Now, to answer your question, at the end of the day, this is exactly what Mr. Goenka wants to tell the shareholders when they are considering the vote for his removal. What he wants to tell them is, if you take the Invesco proposal into consideration and remove me, your deal with Sony will be in jeopardy. If the deal with Sony comes into jeopardy, then in that event, you lose as shareholders of Zee. And this appears to be, at least in the minds of Invesco, the strategy which Zee's promoters are adopting. They may be overthinking the issue. It may be that they are wrong in their assumptions, but this appears to be their apprehension. And that is the reason why they are saying that no, first, we are not saying that we are not going to go through with the Sony deal. They will probably go back to Sony and say, we are perfectly willing to consider the deal. We think it's a good match for the two of us, and we will consider it on similar terms which you are proposing today. Maybe commercials will have to be worked out, as Hetal has rightly pointed out. That's a different matter. But they are not in principle opposed to the Sony deal, because they believe also, in my view, that it would add value to the shares, and they, being a major shareholder, would obviously welcome that merger.
Yeah.
So their opposition is to Mr. Goenka trying to link the deal with his continued existence in the company. And that is what they want to do away with. And that is what gives rise to the presumption. Mr. Gupta is right. No one can say with certainty. I don't know what's in Zee's mind, Goenka's mind, or Invesco's mind. But it leads to an apprehension or a presumption that the reason why this step was taken to conclude this term sheet with Sony and to have it announced was to send a signal to shareholders as and when a meeting is called that, look, think twice before you vote in favor of the proposal to remove me. It may well be that the deal will still go through. It may well be that Sony will say, no, listen, we are not really insisting and being adamant on Goenka's continuance. But perhaps this is what is lurking in the mind of Invesco, and perhaps a strategy which was being contemplated by Goenka.
Yeah, so it's exciting. It's an exciting boardroom battle, and it's exciting not only just because of the personalities involved. It's also a very interesting story to watch out for, because it's laying standards and precedents for corporate governance and for the assertion of shareholder rights, what we are now calling shareholder activism as well. So we'll watch this story very carefully. I want to thank all of you for joining us on the lead story this evening on the India Development Debate.